Mr. Mayor, do you want to say something first?
Yes, Your Honor. At the outset, the state would like to raise a legal point. The state has 7 witnesses and is ready to proceed with all 7, but the state would like to raise an argument that we may not even need to go that far. The defendants are charged with criminal trespass and not contempt. There are 3 elements of criminal trespass. First, the defendants knowingly 2, entered or remained in any place in defiance of an order to leave or not to enter, and 3, said order having been personally communicated to them by the owner or other authorized person. And there are 3 elements to contempt. A valid court order covering the defendant exists, the defendant had notice of the order, and the defendant intentionally committed acts in violation of that order. As shown by the elements of each, with contempt, the state has to prove that there was a valid order. With criminal trespass, however, Your Honor, the state only has to prove that it was an order made by an authorized or valid person, who in the instant case was the sheriff of Cheshire County. And under criminal trespass, there is no element that the state proved or that it has to show that the order was valid. The state would argue that after having been served with the order in the incident case, an order that the defendant felt was invalid, their remedy was to bring an action in superior court to invalidate it and not to simply violate it. And in the instant case, the underlying charge is criminal trespass and not contempt. The focus is not really on the validity of the order, but rather the owner of the property was authorized to serve the order. And in the instant case, the defendants were given the order not to enter Cheshire County Superior Court by a duly authorized person, the sheriff of Cheshire County, and then they knowingly violated that order. And so, again, the state would argue that there really is no need for this honorable court to hold an evidentiary hearing on whether the no trespass order is valid or not, and rather should look to the elements of the crime for which the defendants are charged and indicate that in this case, the remedy, again, is for the defendant to go to Superior Court and file a motion for a hearing to be heard on the merits of the validity of that order. And the state would therefore request that this honorable court hold this case in abeyance and order that the defendants well, not rule on the not have this hearing, not rule on the instant charge, and if the defendants wish to argue the validity of the order itself, that needs to be done over at Superior Court.
Well, when did you know you were going to make this motion?
That was raised peripherally in the state's answer and objection to...
Well, you're making it directly. How much notice did Mr. Meyer have?
Well, he has notice from the perspective of having it in referenced in the state's answer and objection.
Your Honor, I don't really need advance notice to address on this issue, although I would request that the permission to file a memorandum afterwards, just like provide the court with citations. I think Attorney Lawrence made 2 points. One is that a criminal trespass statute does not require a valid order. And second is that the defendants must challenge the validity of the order prior to violating it. Now, the first of the 2 points is just completely incorrect. I mean, a criminal trespass order is dependent I mean, a criminal trespass conviction is dependent on there being a valid order. I mean, otherwise it's not criminal trespass. If the sheriff didn't have the legal and constitutional authority to issue the order, the banning order that he did. But I think the more important point is the second point, which is the argument that before the defendant can, that rather than challenging an order through a criminal defense proceeding, you need to first challenge it civilly before the violation of the order. And I guess I have two responses to that. First of all, this order was challenged civilly. Now, David said it has to be filed challenged in Superior Court. I'm not quite sure where he got that from. It has to be. It was challenged civilly in this court. The same order in a case called State v. Bo Davis. It was challenged as a civil, essentially as a civil matter, order from the court to allow him to attend hearings without getting permission of the sheriff. That order, actually, I said no, it wasn't. Sorry, my mistake. It was challenged. It wasn't Superior Court.
There was someplace along the line I saw an order or a decision from Judge McGuire.
Right, Judge McGuire, February 15, 2012, which ironically, up until now, the prosecution has relied upon showing that the order is valid. So in fact, this same order was challenged civilly in court, in Superior Court, and upheld. So the argument really lacks a factual premise. But secondly, as a matter of federal law, when dealing with this issue, the United States First Circuit Court of Appeals, in a case called United States v. Morad, which is a case from 2002.
How does that spell?
And I'll provide the site in a subsequent memorandum. But essentially what the court said is that although it is the normal rule that a order of this type should first be challenged civilly before being violated, that there is an exception where the order is transparently invalid. And our position is that this order is transparently invalid. So that order would be applicable here, even if, again, even if this hadn't been challenged civilly, which it has been. Now, the final point in terms of David's argument that there shouldn't be an evidentiary hearing is sort of counterintuitive, because the evidentiary hearing was, the reason we're having this hearing is at his request. So it's the prosecution that has asked this court for leave to put in testimony. And the reason for the hearing today, I mean, our position is that this order is invalid as a matter of law. The prosecution has sought to sustain the order through the introduction of testimony. The court scheduled a hearing for today, so I can imagine no conceivable reason to further delay this proceeding.
Your Honor, just very briefly, regarding Attorney Meyer's first argument regarding the criminal trespass dependent upon it being a valid order, the plain language of the statute does not provide that, as opposed to the contempt statute, which does.
What is a defendant to do if, let's say that, first of all, let's say there's no state action involved. Let's say some landlord has some agent, and they're saying, we don't want you to trespass. And the agent delivers a letter to somebody down the street, they don't want trespassing on the property anymore. But let's say the agent really isn't an agent. Let's say somebody just took it on their own to give somebody no trespass order and said this is from the landlord. Now I've got the authority. What does the defendant do? Go to Superior Court and challenge that?
Well, they go to court to, in the first instance, to challenge the validity of the,
No, defendant challenges within the confines of the criminal case's choice. You don't have a separate case on that. I don't see how it would be any different here. I understand your argument, but I don't see how the reasonableness, the validity, and the constitutionality of the order are I think, right for this court to entertain the evidence on that. It's the defendant's motion. I don't know. Did you say you were going to put on witnesses?
Yes, well, the plaintiff, yes, the defendant is going to call court's prepared, is going to call as its first witness.
Well, I'm inclined to go ahead. I mean, I think your issue is still preserved, but I think we're gonna have to go forward with the evidence as we plan to do it today. And you'll each do memoranda on that, I guess?
Sure. Very good, thank you, Your Honor.
Your Honor, defendants call as their first witness Richard Foote.